Welcome back, everyone. In today's video, we're covering a self-proclaimed sovereign citizen who has recently been charged with DUI and decided to handle his own defense in court. Over the last few months, I've been following his case closely, and now the situation has finally reached trial. He enters the courtroom confident and prepared to challenge the system, but as the hearing moves forward, things quickly begin to fall apart for him in ways he clearly did not expect.
I'm here to make a special appearance.
Well, what's your name, sir? Can you tell me your name?
Don Lyons.
Okay, we're on 2508, scene 2346, State v. Don Lyons, who is here today via Zoom. State's again present. Let's see, advised at your initial hearing you wanted to proceed pro se, without an attorney. Is that still your intent today, sir?
Say it again.
Is it still your intent to go forward without an attorney?
Yes, sir.
Okay, so we have two options today. You can either ask for some more time to either put together a defense or hire counsel or talk to the state about any potential resolution, or we can simply set this matter for a bench trial. Which of those two options would you like today, sir?
I would need to request a continuance to work on my defense.
Any objection? I say no objection. Right. Looking to age of the case, that's fine. So I'm going to reset this for December 22nd at 8:30. So Mr. Lyons, we'll see you back here on that date and time.
Say it again. You said
December 22nd at 8:30.
December 22nd. All right, thank you.
Yep. All right, so we're on 2508 CM 2346. State v. Don Lyons, who's here today in person. State is also present. So we're here. All right, so the state has filed one additional charge. It's for count 3 operating vehicle with an ACE of 0.15 or more. The state alleges that on about July 21st of this year in Montgomery County, state of Indiana, you did operate a vehicle with an alcohol concentration equivalent to at least 1,500 of a gram of alcohol per 100 milliliters of your blood. Class A misdemeanor carries with it a penalty from 0 to 365 days, Montgomery County Jail, and a fine of up to $5,000. Do you understand the allegations against you and the possible penalties?
I'm here to make a special appearance, and I had sent a motion.
Yeah, so that was filed this morning.
A motion to get this dismissed.
Okay, since that was just filed today, I don't even know if the state's received a copy of that. I'm not going to set that for hearing today, but what we'll do is we'll set this for another pretrial conference, and that we can address that motion at that point. We'll do that. Set that, say January 26th at 9:30.
What date is that?
January 26th.
What that date? Oh, no,
Okay, we're gonna do the 28th.
Yeah, 28th.
Okay, we'll say January 28th at 10 a.m.
As expected, the early court appearances followed a familiar pattern. The defendant spent most of the time questioning the court's authority, making special appearance claims, and presenting arguments that failed to make any real impact during the proceedings. The judge remained patient while continuing to move the case forward step by step. After several unsuccessful attempts to shift the direction of the hearing, the case finally moved ahead to his third court appearance, where the situation became far more serious.
There we go. This is 2508 CM 2346, State v. Don Lyons, who's here today via Zoom. State's here in the courtroom. We're set for a pretrial conference. Lyons, the first question is, you've been appearing pro se. Is that still your intent, or do you intend on hiring counsel, or do you want me to consider appointing an attorney for you?
No.
Okay. So I'm going to advise you, just in proceeding pro se, you are going to be held to the same standard as if you were an attorney. You're going to be expected to understand the rules of trial procedure, rules of evidence, rules of criminal procedure. Do you understand all that if you go forward without an attorney?
Yes.
Okay, so I think
I had wrote an affidavit. No, I'm still waiting for a response.
okay, and I see that affidavit, and I think we received that the date of our last hearing. It doesn't look
Correct.
too. Doesn't make any specific requests. It's a request for dismissal of charges, and this does not comply with Criminal Rule 2.7. It's also not an appropriate motion to suppress.
I have to object to that.
Understood. So what I'm going to do is I'm just going to set this matter for a bench trial. Set that April 1st at 1:30. So that's going to be the court's order for today. This will be set for a bench trial April 1st at 1:30. And all parties are going to be ordered to be here in person on that date.
April 1st, what time?
Nothing especially important took place during that appearance. It mainly showed that he still had very little understanding of how courtroom procedures actually work. As the case moved into the bench trial, the situation became even more difficult for him. He made very limited attempts to question or challenge the statements given by the witnesses, which only weakened his position further. The trial quickly turned into a clear example of how risky it can be to represent yourself without proper preparation or legal knowledge.
Says 2508 CM 2346, State v. Don Lyons. It's here today in person. State's President and Prosecutor Tyler Trulock sets it for a bench trial on counts 2 and 3. Count 1 was previously dismissed. Michelle, I just say you wanted to note something before we begin?
Yes, I'm here for make a special appearance.
Okay, and what do you mean by that?
Like I know I'm here to represent myself and challenge the jurisdiction.
What's your request to challenge the jurisdiction?
The OWI
Okay.
that was there, and they had a warrant for to take my body.
As the bench trial officially began, the defendant immediately stated that he was making a special appearance before the court. The judge confirmed that the case would proceed on the remaining 2 counts after the first charge had already been dismissed. Representing himself during the hearing, the defendant claimed he wanted to challenge the court's authority over the case. He then argued that officials mentioned a warrant related to his detention, but according to him, he had never personally seen one, which became the main point of his argument.
Any of the procedural issues or evidentiary areas has come and gone. Today we're set for a trial on the facts that matter. So if you want issues with the evidence being introduced as it's being introduced, you can make appropriate objections. We're going to go forward today. State, you ready to proceed?
Yes, sir.
Go ahead.
Your Honor, the state calls Trooper Devin Walsh.
Any questions, Mr. Lyons?
Yes. What side of the car you was on when you first said you had smelled? When you had first asked, was y'all smoking any marijuana in the car?
Passenger side.
And then right after that, you had said you had smelled alcohol, right?
Yes.
It was on the passenger side?
Smelled alcohol on the passenger side and on the driver side.
But she was on the passenger side first, right, when you said it, right?
Yeah.
Alright. So when you came to the driver's side, and I got out the car and I told you I refuse to take the test. We went to the hospital. How can I say? When did you present me the warrant?
I read you the warrant right before we drew your blood. I got him supposed to.
This is on file.
It's on camera.
Is it on file though?
They have my body camera. They have it all.
On file.
So you have to ask questions about it.
So you don't know if it's on file or not.
They have all my body camera, dash camera, and
You don't know.
all that. I sent it to him, so I would assume so.
You said the warrant was signed around 6:21.
Well, it was around 6:21, so I'd have read you the warrant that I did. So I did read it to you right before the blood draw happened.
You have any proof of the audio?
Audio, it's on my body camera. It's on all the time.
I can't see it. And I see it. But I really don't recall. And if there was a warrant, you know what I'm saying?
It was
go about it like that. But I don't recall it no more.
Well, I should say that.
Like I was on, I do, but not right. Not.
At one point during the exchange, a sharp comment was made suggesting that the defendant may not clearly remember the situation because of his condition at the time of the incident. The remark immediately changed the tone inside the courtroom and added more tension to the discussion. Instead of helping his argument, the moment only highlighted how quickly the hearing was becoming more difficult for him as the trial continued moving forward.
Thank you, ma'am. Mr. Lyons, do you have any questions for this witness?
Yes. That was a while ago, but you know around the time that they took my blood.
I don't remember.
That's all I had.
Anything else that's safe?
No, you're.
You can step down, ma'am.
Okay.
Mr. Nurtown, is there anything else you'd like the court to know at this point?
Do not believe so.
No. Thank you. Do you have any questions, Mr. Lyons?
No, sir.
You can step down, ma'am.
This was the only witness the defendant seriously attempted to question during the trial, but nearly all of his attention stayed focused on whether a warrant had been read to him while he was in the hospital. He did not raise deeper questions about the investigation or challenge the evidence in any meaningful way. The following witnesses included a hospital nurse and a laboratory technician connected to the blood sample testing. During both cross-examinations, his questions remained brief and had little effect on the overall case.
I was thinking I was gonna say it to me. I didn't know I had to bow for it. That's my ignorance. I don't have no evidence. No, sir.
So
Today's trial, the state needed to prove, carry their burden, need to prove beyond a reasonable doubt on count 2 that Mr. Lyons had operated a vehicle while intoxicated, and on count 3 that it operated with an ACE of 0.15 or above. State has proven that he was operating a vehicle, and through the expert testimony has proven both counts 2 and 3 beyond a reasonable doubt. We can proceed to sentencing. Mr. Lyons, is there anything you'd like me to consider on sentencing?
My grad got to get back home today, and I really don't remember or recall them showing me that warrant in that hospital. I kind of remember that night for the most part, but I was hoping to see the audio or see the documents of timing of the warrant. What they were presenting, that'd be nice.
any on sentencing state?
Just a few questions here. Mr. Lyons, are you currently employed?
Yes, sir.
Where do you work?
Work at the train station right now, Earth Spot.
Okay. Is that a full-time job?
Yes, sir. Now it is. I was working 2 at first.
Okay. And where do you live?
Well,
Okay. Louisville, Kentucky.
yes, sir.
Mr. Lyons, do you have any criminal history of any kind?
Yeah, look right. Like the criminal history.
Yes.
Yeah, look right. Mainly tried. Yeah, but
So what have you been convicted of criminally?
that's some marijuana. on some marijuana. Pretty much.
Is it possession of marijuana?
Yeah, that's
Okay. Is that the only thing you've been convicted of?
I think that's right now.
Okay. No previous operating while intoxicated convictions, anything like that?
With the testimony and evidence left mostly unchallenged during the trial, the judge ultimately found the defendant guilty on the remaining charges. The court explained that the decision was strongly supported by the evidence presented and the expert testimony that faced very little opposition during the hearing. After the ruling was announced, attention quickly shifted towards sentencing, where the outcome turned out to be far different from what many people in the courtroom may have expected.
So state,
No.
what's the state's request on sentence today?
Your Honor, state doesn't have any reason to doubt what Mr. Lyons said about this being his first operating while intoxicated conviction. The state is concerned by the fact that Mr. Lyons was operating a vehicle with an alcohol concentration above 0.15. However, it does not appear that Mr. Lyons has many, if any, ties to this community. So the state's first inclination as to sentencing would be to ask for just a short executed sentence for him to be done with this case. If the court's not inclined to do that, the state would just request a 365-day sentence suspended to probation, as well as a reasonable fine and license suspension. Thank you, Your Honor.
So, yeah, those are my things to consider. Understandably, if I would put you on probation, be a misdemeanor probation that is difficult to transfer across state lines, and that's going to be very difficult to have done with you living in Louisville, Kentucky. So what the court's going to do today, given your lack of criminal history, is I'm going to sentence you to 10 days in the Montgomery County Jail. That's 5 actual. So you've got credit for 1 actual day already when you were first arrested. So you're going to have 4 days remaining to do. So you're going to be taken into custody, placed in the custody of Montgomery County Jail today. You're going to be released 4 days from today. And there's going to be court costs of $189.50. And I'm not going to impose any additional fine. There's a $200 alcohol countermeasure fee. There's also going to be a 90-day license suspension that's going to go into effect tonight at midnight.
That's suspension for the state of Indiana.
Yes. So I'm not sure how that transfers to Kentucky. That's going to be the order for today. So you're going to be remanded in custody.
All right. So what about I don't know, my granny though. She can't really see like that. Like I gotta help her get her. You know?
Well, sir, you've known for quite some time that you were scheduled for trial today.
Yeah.
And so plans you've made are on you. So that's going to be the order for today.
I'll get out for that.
And I will notify you, you have 30 days to file a notice of appeal if you want to appeal this decision.
It seems someone else may now have to step in and handle the ride home after everything that happened in court. The case serves as a reminder that responsibility matters, especially when other people rely on your decisions and actions. It also shows how important it is to approach legal situations seriously and with a clear understanding of the process. That brings today's video to an end. More courtroom cases and unusual hearings will be covered soon, so stay tuned for future uploads and discussions on the channel.